Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program's been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources that'll help you decide whether or not you might actually want to handle some issues yourself. Perhaps you do want to contact a lawyer. In either case, if you are prepared, you'll be better prepared, and so will the professional who you select. Our goal, of course, is to save you time, money, energy, and hopefully help you to achieve better results. We welcome and thank the Bazar and Associates law firm in East Providence for their continuing support, their information and insights for each session, and we want to welcome attorney David Bazar.
Thanks, Deb.
So let's get to it. Today, no one likes to talk about death and dying, but it's important. So wills, estates, trust, healthcare directives, probate, what you need to know. Apparently, even though everyone should know that they need at least a will, survey says almost 65% of American adults today don't have wills, and even 50% of those who have children don't have wills. Apparently, these instruments are all meant to help you take control of your life medically and financially so that you have less risk and can take care of the things that you need to. So, David, let's start with what we need to know and why it matters. Where should we start? Perhaps with everybody's going to die. What's the minimum level of protection that they can provide for their family with these instruments?
So oftentimes when people call me about estate planning, in wills in particular, they come in and talk about trusts versus wills and which one do I need and why should I have one versus the other. And it's sort of an interesting question that results in the same discussion every time, which is, what are you trying to accomplish and what are you trying to avoid? So the whole purpose of wills is to pass property from one generation to the next, or to make sure that whatever property you do have ends up where you want it when you die. A trust can accomplish the same thing with a little bit of a different procedure for doing that, but in the end, the purpose of using both of those can be to pass property after you die. So a will is the simplest way to do that.
And apparently there's good reason for people to think about an estate too, but at the bare minimum, a will. I understand from looking online, and we're here to provide some resources, people can do some things online, at least get a good start on it. But what do they need to do if they decide to do it online and need to have it become legal and valid as a document? Do they still need to come to you to put a rubber stamp on it to check it, or can someone else do that? How does that work, David?
So a simple will plan. The document is really just one piece of what a lawyer's role is in doing that. And when you come to me, you're not asking me to give you documents so that you can accomplish passing property to someone else, but you're also coming to me for advice. And so when someone comes in and says, I just need a simple will and I don't need advice on anything, could they do that online? Perhaps. But it's not just the document that is necessary, it's the execution of the document, which can be slightly different in whatever state you're executing it as to what the requirements are. And there are other documents that you probably should have as part of a well-planned estate. So taking that one step at a time. Well, what is the advice? What can possibly be so difficult that I can't do it myself? Well, oftentimes people come and they're talking about doing wills because they have young children. And so it's not just the will to pass the property to the children because they're too young to get the property. So we talk about doing something called a will with a testamentary trust, which is a trust that doesn't get funded until the will is probated and the property goes into the trust to be held by a trustee for the benefit of the children. There's a lot of information that you need to do that properly and a lot of issues that need to be addressed. For example, how old do you want your children to be when they get their money? Do you want the trustee to have discretion to use the money for them for school, for medical issues, for any other types of issues that may come up while they're still minors? Do you want the trustee to have their discretion limited or expansive? Do you want the trustee to be able to take the money if there's not enough of it and transfer it to the child at an earlier than the so-called termination date of the trust? there's a lot of things that go into that. And who would be a proper trustee? That's another discussion that as a lawyer we can have and go through all of the options and talk to people about. Go
In
ahead.
the times that we've talked about wills in various sessions, an interesting question came up. If you were a married person with children, can you exclude your spouse from your will and just favor your children? Is that a possibility?
Okay, so disinheriting people, which is another issue that can come up in a will in determining what you can and cannot do. So in many states, there are rules as to what you have to do and what you can do as far as a spouse goes. And then, of course, we also oftentimes have people come in who have 2 or 3 or 4 children and may want to disinherit one of the children. So in Rhode Island, for example, if I have a spouse and I want to disinherit her in the will, I can do that, but she has a right to elect against the will when it goes to probate.
Challenge it?
Well, not necessarily challenge it,
Okay.
but to elect against it. So if you don't leave that spouse anything in the will, she can claim a life estate, for example, in any real estate that's in your name at the time of your death. So a will is not a really effective way of disinheriting a spouse. There are other ways to do that. As far as children goes, you have the ability to include or disinherit any child you want, but what you have to do is specifically reference the child and say that you're not including them in the will it's intentional, it's not by mistake or oversight, and that there's no duress or any other reason that you're doing it, and you may even want to lay out the reasons why you're doing that.
A question came up one other time after we had done a session about wills. Is it possible to write into a will that if someone challenges it, contests it, that can automatically disqualify them from anything that had been planned as their inheritance?
Yes, you can do that, and oftentimes that's standard language in wills, so that anyone who challenges it, if they're included in the will be disinherited as a result of challenging the will.
If you don't have a will, what happens?
So if you don't have a will and you die with property, that passes through the intestacy laws of whatever state you live in. So in some states, it could be that it gets split 50-50 between a spouse and children if there are a spouse and children. In other states, for example, in Rhode Island with real estate, the spouse gets that life estate that we talked about, which means while she's alive, she has the ownership and use of the property, and the remainder interest passes to the children upon her death. If it's personal property, again, there's different rules of their children, no children, spouse, no spouse. And so whatever the intestacy law of the state that you live in applies to how that gets passed.
And if someone starts to do a will, has questions, or does a will and is comfortable with what it is, can they just have 2 people as witnesses sign it? Does that make it legal?
Depends what state you're in.
Okay.
And then there are some other issues.
Such as?
So if you have 2 people witness your will, which would pass muster in Rhode Island, the will is valid, but can it just be admitted to probate? And the answer is no, because in Rhode Island, that will has to either have the witnesses come to court and testify that the person who signed it was of sound mind at the time they signed it and they were there in the presence of that person, or you do what's called a self-proving will, which is what attorneys will draft, which has an affidavit attached to it, which lays out all of those things and is then notarized.
For a very simple will, maybe someone has a house, a car, and a little bit of money. What does it cost range for a will to be done?
The will is just one piece
Yes.
of a proper estate plan. There are other documents that you should have, which include in Rhode Island a living will, a healthcare power of attorney, a power of attorney, and they all do different things. The power of attorney is designed to have someone who can help you while you're alive, either when you become disabled or if you want the help sooner, to assist in all financial matters. And
Medical too, David, or
that's
just
the
financial?
That's the healthcare power of attorney. And the healthcare power of attorney in Rhode Island would also serve to put choices out there that you might have as to whether you want to be kept alive artificially, with heroic measures being used or just to be able to pass naturally.
Palliative care.
Yes, and what you want and that type of thing. And so we usually ask the folks that we're dealing with what they want and spell that out so that the final decision, although may rest with whoever you appoint as your power of attorney, will have guidance from you. And in Massachusetts, they call it a healthcare proxy. It serves the same purpose.
And those package or that suite of documents that people basically need, can you give us a range about what that might cost if it is a simple but forthright 3 or 4 documents?
All right.
A range.
So it depends on the attorney. They might charge you anywhere from $500 to $1,500 depending on the complexity of what goes into that. Because remember, we started talking about the will with children, and we only hit testamentary trust. But you should also think about naming a guardian for your children. So if something happens to both mom and dad at the same time, you don't necessarily have to have the same person take care of the children physically as the person who takes care of the money. In fact, sometimes it's a good idea to separate those responsibilities. So we talk about naming guardians. You have to talk about who the executor is going to be and backup executors. Those are the folks who are responsible for making sure that the will gets to probate and that the terms of the will are followed and carried out. So there are discussions that a good attorney will have with his clients as they go through the different decisions that have to be made as you go into that process.
And just in this brief time that we've been addressing these, you certainly quickly fired off enough questions that make me think that perhaps if someone walks into you and says, here, this is what I want to do, that those questions may be things that they have not even begun to consider, and you know enough to ask about those questions. When that happens, do they need to go back home and perhaps cogitate on that a little bit and then come back with some other alternatives or thoughts?
Yeah, oftentimes it is a process because the first step is to think about even doing it. So oftentimes a client will make an appointment and then come in and they see me and we start discussing the different options. And given the situation, I explained the difference between a will plan and a trust plan. A trust is the same idea of passing property, but there may be reasons to create the trust while you're living, so it would be a living trust, and usually a living revocable trust, which means you put your assets into that vehicle now, so that when you die or if you become disabled, there's a plan in place as to what's going to happen with that property. The difference between a trust plan and a will plan is the trust plan avoids probate. And that's oftentimes something that's on people's mind. They hear horror stories about probate. We don't want our kids waiting for our property to pass through probate before they get it. We want to do it in some other fashion, and we've heard about trust. So we discuss the benefits and the downside of trust. The benefit of the trust is you do avoid probate. You have control over what's going on. It's not a public document, so people can't go to probate court and take a look at your inventory and see what you had for assets. So there's a number of advantages to doing it through a trust plan. The disadvantage is it's expensive because you're now taking all your assets and you are making sure that they get funded into that trust. Because if you don't put the assets into the trust, then some of the purpose is lost because any assets that aren't in the trust have to go through probate.
Those become part of the person's will and hope that they've been named.
Right.
So that you don't have more challenges and more troubles, I assume.
With every trust plan, there's still a will because assets can get missed or something else can come up that would require probate. And in the plan, the will's usually called a pour-over will because it pours all of the property that didn't get into the trust in the first place into the trust through probate.
Would you likely sit down with someone and say, tell me about your musical instruments, your artwork, your jewelry, your furs, the number of boats you have? Some things someone might likely think about. The boat, easily. Maybe jewelry. I was just reading and preparing for this that some people have very substantial wine collections or perhaps a wine cellar or whatever. And that certainly is something that in and of itself needed to be documented. Do you go through a checklist that is, I'm sure, fairly readily available to you and also something that you've been through enough so that you cover all of the bases, again, that someone hasn't thought of?
Sure. And the more complex the estate, the more that you have to go through, of course. But oftentimes, actually, the discussion might start with, tell me about your family and your interests and your goals, because although the property is really important and needs to be addressed, sometimes the makeup of the family will direct how you want to do things. The goals and interests of a person may affect how you want to do things. For example, if you have a fairly large estate, as you were talking about, with art and wine collections and all these other things, and number of assets on top of that, you might want to consider a charitable trust, charitable donations. Does the art belong in a museum? So those are discussions that you might have with the client on that. And if it's a more simple estate, you still want to have that discussion, because there may be someone who's very religious and said, my children are going to get enough money from me, but I'd like to fund something at the church or something like that. So the discussion isn't just about the property, but about yourself, your goals, your family, your interests.
And I guess the one other unspoken thing that comes to mind is the dynamics of a family situation, about who's able to do things, how they're likely to respond to how this is taken care of, and I imagine that also drives wills, trusts, and what's seen and what's not seen.
Really, really important to deal with all of that up front, because family dynamics, many more times than anything else, can create problems after the fact. So oftentimes with large families, we'll bring people in. The mom and dad might want to sit down with older children and say, this is how we see things going. This is why we want so-and-so in charge. This is how it's going to be. And so everybody is on board up front, because I've seen the disasters on the other side where families just break apart over silly things that don't have to happen.
A few minutes ago, I asked you about what it could cost to do a will. Yet on the other side, from what I had read, those who have not done it properly and had a will challenged or something challenged cost much more money, took much more time as well. So the advanced planning certainly seemed to make sense, and I'm sure that you're a strong advocate of that. Not that you can't handle it on the other side, too.
Right,
but
but if you can avoid it, that's what you want, because you don't want to have unnecessary fights over things that if you deal with them up front, you don't have to worry about afterwards. And that's what I was just talking about before. It's the same idea of, okay, I have 4 children, one of them is really good with money, one of them is really good with health issues, and so forth and so on. So you may appoint different children to do different things to help you as you're older, and they're more able to help out with different ideas and functions of what needs to be done. So it's a good thing to discuss those things and make sure everyone feels included, and therefore is less likely to create problems afterwards. You do have those situations where you might be cutting somebody out altogether. Sometimes it's an uncomfortable discussion to have, and you don't want to do that, and maybe that's better to wait. But whatever it is, it's really important to discuss that with the attorney up front, so they can help guide you through what's the best way to deal with these things. And all the best planning sometimes still will not stop the fights from happening.
when you're dealing with a will first, you have an option of who you would want to be the executor of the will. Yes.
Yeah.
Should you as the lawyer, ask that person who's going to be the executor to be sitting in on a meeting to explain to them what they need to do, as opposed to with an estate, with a trust? Would you be more likely to do that then? And
Yeah.
how does that work?
So
in your
a
opinion?
trust versus a will.
Mm-hmm.
With a will, it's not always necessary to let the executor know that you're the executor, but it's, in my opinion, if there's no reason not to, you should. And frankly, make sure that the person wants to take on the responsibilities of what they'd have to do. So what we often do is discuss that with our clients up front. Who do you think should be the executor? And we tell them that if they do that appointment of a certain person, and they don't want them to know what's in the will, but they need to know where the will is, whether it's in our office, which will hold them in a fireproof vault, or if it's somewhere that they keep in a house, that the executor, if something does happen, will have access to be able to get the will so they can get it to probate. So there really certainly needs to be some discussion with the executor beforehand, before you die, that is.
And it seems like there's an awful lot of work that goes into this on the part of the person who is going to have the will or the estate. Apart from you suggesting or asking these questions that leads you to make a decision with your client about what needs to be done, it seems that if you're doing an estate plan, that someone still has to take that boat, that plane, that train, the property, and move it from however they have it, wherever they have it, the deeds. They have to do work to get it to you so that the trust, rather than they, hold this material. Can you explain a little bit about what goes on and what that process is about?
So if you're doing a trust-centered plan, in order for that plan to work, the items that you're talking about need to be titled to the trust. So if you have a plane, you might want to make sure that it's owned by the Deborah Murray's 1997 Living Trust. And the more items that you have in the trust, the less there is to do after your death. And that's part of the process of having a good attorney to work with who knows that it's not just about drafting a document, because remember, that's what we talked about. Yep, can you go online and draft a trust? Probably can. Does that help? Nope, because if you don't fund it, then it's not effective. And so having a good attorney who knows that it's a two-step process at least, and that the funding of the trust is almost as important as the words that are in the trust, and will make sure that that gets completed properly, that's a really important step in the whole process.
So you're likely to have your office call and say, you need to get me the deed to this, or the ownership or title to that, and make sure that everything is taken care of and registered properly so that it's done.
So when
Cross those T's.
When we're doing a trust-centered plan, there's a document that gets sent out, which is, we call it a PIF, a personal information form. And on that form is all of the information about the family, all of the information about the people who will be involved in the estate process or the trust, and all of the property. And then once we have all that listed, we will then make sure that we contact the stockbroker who's got the stock account to make sure they know what the name is that has to go on that. That if there's a piece of property that's going in a trust, and that's a whole nother discussion for another day as to whether the property is better off in the trust or not in the trust. But if it is, that the deeds are done so that's in the trust. And whatever other accounts, bank accounts, savings accounts, checking accounts, if they need to be in the trust, they're put in the trust as well. And so part of what we would do, and the attorneys we work with that do these things, is to make sure that all of the assets are properly titled.
And even if you aren't a billionaire, you can still need and make good use of a trust. At what point do you decide that you need to call in somebody who's more on the financial side to do the number crunching to see how that's best serves your client's needs? How does that happen?
So
that's probably another whole series to discuss.
The in-depth detail of it is, but the long and short of it would be that if you have an estate that could be considered a taxable estate, which is over whatever number of millions of dollars in Massachusetts or Rhode Island, plus the $5 million plus federal exemption, then you really want to be careful and take advantage of all of your deductions and exemptions and types of things that you can by creating separate trusts between a husband and a wife, a family trust, a charitable trust if that's necessary. And the attorneys that we work with will be able to really sit down with someone and give them an in-depth explanation of what tax benefits they can get and how best to use those.
Would it likely be a lawyer, or would it be an accountant, or are there some that can do both comfortably?
Well, when you get to that higher end of planning, we usually will work with the person's accountant, a person's financial advisor, and we as the lawyers would be involved.
And back to wills for a moment. Apparently, it's very popular these days for people to discuss having a video will. They might not have wanted to sit down and write things, but a video would do it all. Care to caution or weigh in on that, David?
Yeah, I would say that a videotaped execution of a will where somebody might challenge somebody's state of mind at the time they were signing it is probably a pretty good idea, but as far as I know, you still need the written document because it still has to be executed in accordance with the rules of whatever state that you live in when you sign it. So I do not believe that Rhode Island, for example, would allow the admission to probate of a will that is a videotape of somebody. It still requires signatures and witnesses and all of the other formalities that we had before videotapes were around. So what the videotape would serve as is evidence of somebody's state of mind when they sign the will.
So there might be an occasion where you might suggest that that would be an additional
step
to take.
Absolutely. It's actually not, I think it would make a good book too.
How so?
Well, I think there might have been one of John Grisham's books, The
Yes.
Last Will and Testament, that involved videotape signing of a will.
And we didn't speak much about the healthcare directive, but at the very least, is that something that someone can easily do online without having a lawyer? They're not quite ready to do that, but they become ill very quickly. Is that something that's done in a hospital? Care to weigh in on that?
Yeah, they can be. There's statutory forms. Even most lawyers use the statutory forms because that's what the medical professionals would recognize. The discussions that's not in there that would be helpful if you had the time to have it done correctly with an attorney would be talking about who are the appropriate people to be the folks you name in that power of attorney, and also what are your wishes, what additional language would you want to add that the healthcare professionals would recognize.
Can you comment a bit about how long it takes to have a will settled versus things that have gone the estate with a pour-over will?
The trust, you mean?
The trust, excuse
Okay.
me, and a pour-over will.
Sure. So the trust is effective in and of itself. So when you die, the language of whatever's in the trust is already there and can take place. A will needs to go to probate. There's a period of time, 6 months in Rhode Island, where you have to wait for creditors to make claims and that type of thing before the assets can be passed. So there is a delay on getting property passed, and that's, like I said, some of the concern that some people have. But it's really not the end of the world kind of thing that some people think it is if something has to go to probate, but it is time consuming.
Could it take a year, more than a year for a will?
Some estates, because of the complications that may be involved, or if there's a will contest or other challenges, can take several years. But you don't normally expect that in the typical, well-drafted, non-challenged probate.
Good to know. Well, we've certainly covered quite a few of these issues. We hope that this has been a good overview for you. In the coming sessions, we may tackle this in a little greater depth, but thank you for tuning in to the Law Matters, and we hope you'll continue to stay tuned because the law matters to you.